Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. Good afternoon, Mr. Posnett. Can we turn to the issue of casework management, and in particular, the extent to which Post Office policies regulated the revelation of material that showed a procedural weakness in Post Office systems? Can we start, please, by looking at Poll 0010 4777? And if we just look at the foot of the page, please, to get a date, October 2002. So this is whilst you would have been an investigation manager. Do you see that?
Yes.
If we go to the top of the document, please. It's a casework management policy for England and Wales, part of investigation policy. And the aim of the policy is to ensure adequate controls are in place to maintain standards throughout investigation processes. Can we turn to page 2, please? And look at the last bullet point that we can see currently, the one beginning the issue. Thank you. The policy says the issue of dealing with information concerning procedural failures is a difficult one. Some major procedural weaknesses, if they became public knowledge, may have an adverse effect on our business. They may assist others to commit offences against our business, undermine a prosecution case, bring our business into disrepute, or harm relations with major customers. Unless the offender states he is aware that accounting weaknesses exist and that he took advantage of them, it's important not to volunteer that option to the offender during interview. The usual duties of disclosure under Criminal Procedure and Investigations Act 1996 still apply. Is the approach that's set out there one that you used when you were an investigator?
I believe so, yes.
You'll see it refers to major procedural weaknesses may ... undermine a prosecution case if they became public knowledge.
Yes.
And that unless the offender states they're aware and took advantage of them, don't volunteer them in interview. Is that the approach that you took?
I don't recall that that's the approach I took, but if this was the policy at the time I was an investigator, I would have thought by and large I would have adhered to that policy.
Do you know why it was the Post Office's policy not to reveal major procedural weaknesses to people accused of crime?
Because if word got out, others could commit the same crime with those weaknesses still in place.
What about if the weaknesses were not about security or locks and barriers and screens and cash in transit and safes and things like that, physical security issues? What about if they were weaknesses in the accounting integrity of the Horizon system?
I can recall that on the discipline reports, I would sometimes note weaknesses. In terms of the Horizon accounting, I don't recall any of my cases having that.
And so that issue didn't arise for you because you believe there were no weaknesses in Horizon?
That's what I believe, but I don't recollect any of my cases where Horizon was cited anyway.
Can we look, please, to the distinction between the discipline report and the offender report by looking at a different policy, Poll 0011-8101. You'll see this is a guidance document or a guide on the preparation of investigation red label case files. Can you just help us with what a red label case was?
If a case was going to go up for legal advice, there was a red label we used to put on the case file. It said urgent today, must be prioritised during the course of transit.
So it's a signal that it was going for legal advice?
Yes.
Thank you. And can we look, please, at page 10, please, at the foot of the page? And can you see paragraph 2.15, details of failures in security, supervision and procedures and product integrity? This must be a comprehensive list of all failures in security, supervision, procedures and product integrity. And it must be highlighted in bold in the report. Where the investigator concludes that there are no failures, a statement to this effect should be made and highlighted in bold. And then over the page. Significant failures that may affect the successful likelihood of any criminal action and or cause significant damage to the business must be confined solely to the confidential offender report. Care must be exercised when including failures within the discipline report, as obviously this is disclosed to the suspect offender and may have ramifications on both the criminal elements of the inquiry as well as being potentially damaging to the reputational security of the business. If you're in any doubt as to the appropriateness of inclusion or exclusion, you must discuss with your team leader. Do you understand the distinction that's being drawn there between a discipline report and the offender report?
Yes.
And do you understand that any failures that might affect this, the likelihood of successful criminal proceedings were not to be included in the report disclosed to the offender?
Yes.
Why was that?
I don't know, but I mean, this particular document doesn't relate to when I was an investigation manager. I think the previous document you showed, 104777, was applicable during the time frame that I was an investigator. And on that policy, I believe it says something like weaknesses to be put on the report that goes to legal services.
Well, that's the same as this. Include weaknesses in the confidential report that goes to legal services, but don't include them in the one that goes to the suspect.
But on the one that would be more applicable to me when I was an investigator, I'm sure it says in there somewhere that failings, it would be up to legal services to decide whether that should be disclosed.
So do you know why, if a list or a narrative description of failures that might affect the successful likelihood of criminal action against a suspect were not to be disclosed to them in a report which they would receive?
No, other than, as we've mentioned, that if it's a weakness in post office procedures or policies and word got out, it could mean other people could commit the same act. That's what I understood that to be. I didn't understand it to be we need to keep this quiet because, you know, in terms of disclosure.
Who was responsible for deciding what should be disclosed and what should not be disclosed in criminal proceedings?
Again, when I was an investigation manager, there was a Royal Mail Group policy and standards team, and all these things came out from them. As the years went by, Post Office became more independent, and we had our own people drafting policies or reissuing policies.
Who, when you were an investigation manager between 2000 and 2004, in an investigation, was responsible for deciding what fell to be disclosed to a defendant?
The criminal law team?
Did the investigator have any role?
Yes, the investigator would record all the information on the relevant schedules, unused material. Then it went to the criminal law team, and it was up to them to say yay or nay, or this should be on that form rather than that form. So ultimately, they were responsible for disclosing to the defence, but the investigator recorded all the items that they had.
So it was a joint venture in which the investigator was responsible for gathering the material together and scheduling it?
Yes, the investigator had to do their part, and then ultimately it was criminal law team who decided what was...
Who decided on which schedule a document should appear, or whether it should not appear on a schedule at all, and were responsible for giving physical disclosure of that to the defence. Is that right?
Pretty much, yeah. For example, I can remember one criticism I received. I can't remember the name of the lawyer, but I remember them phoning me up because I used to include post notes and bits of paper and all sorts of my unused material. And they said to me, Dave, it's only relevant material you need to disclose. And my view was, well, who's to determine what's relevant and what's not? So if the only criticism for me was to disclose too much, then I was happy to take that criticism. But that's what I mean about I would submit the forms and then criminal law team would decide what gets disclosed. Getting
back to the report issue, do you understand why it was that significant failures that might cause damage to the business should not be included in a report that was disclosed to the offender?
No, other than what I've said.
Okay. Can we move on to poll 303 1005? This is a conduct of criminal investigations policy, and we can see that it came into force in August 2013. Was there a policy like this beforehand that you're aware of? Maybe you want to just flip through some of the pages to see what it looks like, its topics. If we scroll to, that's it, the table of contents.
I think there possibly was, but I don't recall.
Okay. Can we look, please, at page 16? And right at the bottom, please, paragraph 5.11.6. This is dealing with interviews. The policy tells investigators, should the recent second site review be brought up by a suspect or his representative during a PACE interview, the security manager should state, quote, I will listen to any personal concerns or issues that you may have had with the Horizon system during the course of this interview. Was that a policy that you're aware was followed? That there was sort of a pre-prepared script in accordance with that sentence there was read out to suspects?
I wouldn't be aware as to whether that occurred in every case of relevance. What date was this document?
August 2013.
Right. So I think this may have been on the advice of Cartwright King, perhaps.
I mean, you picked up the role of an investigation team leader in 2014 and in 2015, where I think this policy will still have been extant. And plainly the second site review was something that suspects may raise. Would you agree?
Yes.
Was voluntary disclosure given to a suspect of the second site report?
I don't know.
Was there any sense in which the Post Office was seeking to shut down a suspect in interview by reading a pre-prepared line like this back to a suspect who raised the second site report?
I don't know, but on reading that again, I don't think so, because if a suspect raises second sight, this is saying that I will listen to any personal concerns or issues that you may have had. It doesn't sound like to me like it's shutting it down.
Okay, thank you. Can I move to the extent to which you understood the Horizon system could be afflicted by system integrity issues? You tell us in your witness statement that when you were the casework manager at Croydon, so I think we're talking between 2008 and 2010, is that right?
I thought casework manager was 2007, 2008, but yeah.
So I think 2004 to 2007 investigation team manager, 2008 to 2010 fraud risk manager, quite right?
Yes.
In what job was one of your responsibilities, I'll ask it the other way around, the obtaining of ARQ data?
So that was, post office investigators would email into the casework team a request for primarily transaction and event logs. Myself or one of the team would complete an ARQ form and send that to Fujitsu.
So this is when you were working as a casework manager at Croydon?
Yes.
You had that responsibility for a couple of years? My recollection, and bear in mind I seem to have got the date wrong on my testing analyst thing, I thought I was a casework manager between 07 and 08, a number of months. So I would say it's a few months between 07 and 08. And so you held a responsibility for a period of time as a casework manager for obtaining ARQ data from Fujitsu?
Yes.
What training did you have to assist you to understand the nature of ARQ data before you took up that role?
I don't recall any training in respect of that.
Did you have any training about the nature and extent of the data held by Fujitsu, which could potentially assist the Post Office in its investigations and prosecutions before you took up the role?
I don't recall.
When you carried out this work as the person responsible for obtaining the ARQ data from Fujitsu, did you understand the difference between what might be called standard ARQ data and enhanced ARQ data, the latter of which included data that could show where an action in the system had been generated by the system rather than being generated at the counter?
Not that I recall, no.
So you didn't know there was a difference between two species of ARQ data?
I don't think so. I don't recall it. What I do recall is whatever the investigator wanted via the email they sent was what I would put in the ARQ request.
Did you get a handover from the person who was doing the job before you?
Yes.
Did they explain to you that, look, there are different levels of ARQ data available?
Not that I recall.
You were the main point of contact between the two organisations, is this right, in relation to obtaining ARQ data?
Anyone in the casework team could act in getting the data, but I was the liaison point in terms of the relationship between Post Office and Fujitsu.
And so you knew how the system worked for getting data from Fujitsu?
Yes.
And you knew the forms that needed to be filled in order to get that data from Fujitsu?
Yes.
Was the Post Office ever reluctant to request ARQ data from Fujitsu because it would incur cost?
Yes.
Did you ever feel that commercial considerations overshadowed the desire to investigate shortfalls thoroughly and consistently?
I don't recall making that link.
Was there a difference from case to case as to the extent of the ARQ data obtained?
The extent as in
The time period covered?
Yes. Yeah.
And was that sometimes based on cost?
I would say yes.
We're going to get into the detail on this in a minute, but can you give us your overall impression of how significant an issue this was?
From recollection, I don't think it was a significant issue. I think there were a couple of occasions where the volume of information being requested seemed excessive. So if the quota or the volume of requests per month was eaten into to an extent, it could have affected investigators' requests. So that was a sort of juggling act.
Was some data not sought because of cost?
In part, I would say yes.
Can we just turn to, before we get into the detail of ARQ data, a view expressed on Post Office's duties to verify through evidence the existence of a shortfall. And can we look, please, at poll 2014-0164? This is an exchange of emails concerning the Glenmoriston branch from November 2014. And if we can go to page 3, please. And scroll down, please. And keep scrolling. There. Well, that's not very good. If we can just scroll up, please. And scroll up again, please. Thank you. Keep going. Ah, yes, that's it. Thank you. It's an email exchange between you and Angela van den Boogaard. And I needn't, I think, introduce the context for it. But she says, Dave, thanks for letting me have sight of this. I'd be interested to see the response we've sent to the letter, as we need to ensure we're replying in a reasonable yet robust way. And then there's the verification of stock and cash should be evidence enough that there is a shortfall. And if we have evidence of falsification of accounts, this will add further weight. We should be drawing our legal colleagues also. I think that should be drawing on our legal colleagues also, as it is not for the Post Office Limited to demonstrate where the shortfalls have occurred, just that they have. So this is a discussion about what evidence is needed to prove a shortfall. And can you see that Ms. van den Boogaard says the verification of stock and cash should be evidence enough that there is a shortfall? Was that a commonly held view?
I don't recall.
Is it a view that you would subscribe to as an investigator?
As an investigator, the verification of stock and cash should be evidence enough that there is a shortfall.
Essentially, she's saying if at audit a shortfall is shown between what the system says should be there in terms of stock and cash and what is there in stock and cash, that's as far as the Post Office needs to go.
Yes, that would have been evidence of a shortfall.
Would it be sufficient evidence of a shortfall in the context of criminal proceedings?
I don't know. There would be other parts or information relating to the case, but then ultimately it's a decision for people higher up.
I don't think you're answering my question at the moment.
Right.
Would it be your view that in order to prove a loss in a shortfall case against a sub-postmaster, it's sufficient just to show at audit there was a difference between what the system showed ought to be there in terms of cash and stock and what was there in cash and stock?
I think when I was an investigator, that was pretty much it.
And would that apply to the period of 2004, 2000 to 2004, and when you came back to investigations later in your career?
I didn't come back to being an investigator. I don't think that changed. If a cash amount has been declared, which is different to the system, that was a big part. But it's possible that an error notice could come back to explain the loss.
This is saying how far the post office needs to go or doesn't need to go in proving its case. All we need to show is the difference, as I've said, between what the system shows and what's there on the ground as displayed at audit. Was that a view, essentially, that was held commonly?
I would think so, but I can't recall.
Was it a view that you held? I can prove a case, I can put a case before the criminal courts, fit for the criminal courts to consider, of a sub-postmaster stealing money, if there's a difference between what the system says should be in his cash and stock and what's in his cash and stock?
When I was an investigation manager, yes, but there would be other things as well to consider.
Were the other things as well to consider necessary things to consider?
Yes.
What were the other things that were necessary to prove a case?
The points to prove on a particular offence.
What would be the points to prove on a theft case?
Theft case would have been the dishonest appropriation of property belonging to another with the intention to permanently deprive.
So that's the definition of theft.
Yes.
How would that be translated into a sub-postmaster shortfall case? What evidence would you need in order to prove those, depending on how you cut them, 4 or 5 elements of the offence of theft?
His responses or answers to relevant questions put to him or her during interview.
Would they be? It would be necessary to have an admission from him.
It would be necessary to tick off those points to prove yes.
I don't understand what you mean, I'm afraid, Mr. Posnett. This email tends to suggest that we think we can get a case home to port by showing a shortfall at audit.
Yeah.
And I'm asking, is that your view?
I think that would have been my view at the time I was an investigator.
And the other stuff is just trimmings. Is that right?
Well, I would say they were important, but not just trimmings. But yes, I think when I was an investigation manager, if the cash and stock physically there was different to what had been declared, that would have gone a long way to
proving a case of theft.
Yes, but that wouldn't be us. That'd be up to people above. And also, it's if the auditors have contacted various people to get the investigation team involved. So it's not just there's a shortage, we're there. It has to go through certain channels.
That's the people who need to look at it and investigate it from a matter of process.
Yeah.
I'm asking from an evidential point of view. And I think we've reached the position that you say that it was your view when you're an investigator that shortfall at audit was a sufficient basis to make an allegation of crime, and the crime being of theft.
Yes.
And would you subscribe to the other parts of Ms. Van den Bogaard's email, that if there is any evidence of falsification of accounts, that's just additional weight, that's just what I've called trimmings, that's something nice to have but not necessary to have?
Yes.
And would you subscribe to the other part of her email at the end there? It's not necessary for the post office to demonstrate where the shortfalls have occurred, i.e. to prove on which day, through which transaction, or by which means the shortfall have occurred, just that there is a shortfall.
I would disagree with that now.
Why would you disagree with that now?
Because of what we know now.
You wouldn't have disagreed with it at the time, I take it.
I don't know.
So we post office don't have to show by reference to records that the sub-postmaster took the money out of the account by overstating the amount of stamps sold or undervaluing the amount of cash received.
Yeah.
All we have to do is show that at cashing up, at the audit, at the stock take, there's a difference between what Horizon shows should be held and what is in fact held.
Yeah. I would say that's wrong.
You would say that's wrong now.
Well, it was wrong at the time as well.
Why was it wrong at the time?
Because it says it's not for Pol to demonstrate where the shortfalls have occurred, just that they have. Mm-hmm. So there could be a genuine error that could be explained by an error notice that comes back. Yeah.
And so how was it to be investigated how the shortfalls have occurred? If it was wrong at the time, what Ms. Van den Bogaard wrote, and presumably wrong in 2000 and 2004 too, how did the post office go about demonstrating where the shortfall occurred?
Via interview.
That's asking the sub-postmaster.
Yep.
What about by reference to any other evidential source?
Like Horizon?
Yes. Was that done?
I don't recall it being done in my cases, but I am aware that investigators did obtain transaction event logs.
And is that where the suspect raised an issue as to Horizon integrity?
I believe so.
And was that seen as the touch point for whether Horizon needed to be investigated or interrogated or not, depending on whether the suspect raised an issue of Horizon integrity?
I think transaction event logs were obtained by investigators, one, to counter what may be claimed by a sub-postmaster or counter clerk, or two, to back up the investigators' view as to what's happened.
Do you remember that that can come down, thank you. Do you remember that the standard request for ARQ data included amongst the additional requirements that could be made, could be ticked, quote, confirmation that there are no reported system malfunctions during the date range period?
I don't recall that.
Can we look, please, at poll 305 1793? This is an ARQ request in Seema Misra's case, completed by you. Can you see that?
I can, yes.
It's dated the 9th of June 2009. And is this in fairly standard format?
I don't recall, but yes.
You can see that it asks the question whether a witness statement is required, yes or no. What would determine whether a witness statement was required?
If the investigator has asked.
Yes, that's a bit circular. But why would an investigator ask for a witness statement, and why might an investigator not ask for a witness statement when asking for ARQ data?
I don't know. I mean, at this stage, if they're requesting data during an investigation, they wouldn't know at that stage whether a witness statement would be required. So I don't know.
Why might it be required in some cases and not in others?
It may be required if a person was going to plead not guilty, or to cover off any challenges that a person may make.
Does the opposite of that apply, that it wasn't required if it was thought the person was going to plead guilty?
I don't recall, but yes, it could.
And why might that be? Why might a witness statement not be required if it was believed that the person might plead guilty?
Well, I think if someone was going to plead guilty, then it would be a bit of a waste of time doing a witness statement because it won't be required.
What about giving them all of the evidence so they can judge whether to plead guilty or not?
It would be relevant in that situation.
In any event, the form continues, standard format requirements. Can you help us as to what that meant? Were they pre-printed, those standard format requirements?
I don't recall, but I would say yes.
It asks for a report of all transactions and events, including inactivity, log out, log on, log off information for the office, including remittances received, transfers between stock units and error notices, information to be provided in Excel 97 format with each category in a separate column, and then column headers as follows. And then scroll down, please. And then additional requirements, and you would mark this up yes or no?
I would say yes.
Yes, you would mark it up yes or no?
I think so, yes.
And what would determine what information you asked for or didn't ask for?
What the investigation manager is requesting on the email.
So there wasn't a form for the investigator to fill in like this, was there?
I don't believe so, no.
How? Sorry, I interrupted.
I don't think so, because Fujitsu would only deal with the casework team. They shouldn't really have dealt directly with the investigator.
And so how would you decide what information to seek and not to seek?
Purely based on what the investigator is requesting.
In the second box down here, the words, please could you obtain a standard statement from Fujitsu that confirms the Horizon system for the above post office was functioning properly between the 30th of June 2005 and the 14th of January 2008. The statement should state that they've reviewed and summarised all call logs during this period. However, these do not need to be produced. Just breaking that down, why was it necessary to obtain a statement that said the Horizon system was functioning properly?
I don't know.
To what extent were the call logs seen as a measure of whether Horizon was functioning properly at a branch?
I suppose the call logs may identify if a sub-postmaster or clerk believes that the system wasn't functioning properly.
Did you understand whether any additional work was carried out by Fujitsu in the provision of a witness statement which addressed anything other than the call logs?
Not that I recall.
And so you understood that the Fujitsu statement was based on, and only based on, an analysis of the call logs?
Well, I don't know what they... I mean, the bit here that for the system was functioning properly, I don't know, only Fujitsu can answer that, but I don't think you should just look at the call logs to determine whether the system was working correctly.
And why should you not just look at the call logs to determine whether the system is working properly?
Because the call logs can't definitively tell you whether the system was working correctly.
But as a matter of fact, you don't know whether they looked beyond the call logs in the provision of this standard statement that says that it was functioning properly.
Correct. I mean, I assume that they did look at the system because that was the key part of their witness statements to confirm or not, although confirm mainly that the system was working correctly.
The request says that the call logs do not need to be produced. Why did the call logs not need to be produced?
I'm assuming that this is what the investigator has requested.
Well, I think that we may see that this is a standard form of request that's marked yes or no, and that the date range is altered depending on a range of factors.
Yeah, I mean, this part and the top part of the form, I mean, there's no way on earth I can imagine I've completed all these questions. So I think you're right, although I can't recall that there is text already in these boxes, and they may need to be tweaked to reflect a particular office or a particular time frame.
Why did you understand that it wasn't necessary for Fujitsu to produce to Post Office, the prosecutor, the call logs?
I don't know.
They might contain weekly or monthly, or sometimes, as we've seen, even daily complaints by a sub-postmaster.
Yes.
Aren't they relevant information?
Yes, I guess so.
And so I'd just ask again, do you know why the Post Office was asking that, or saying that they needn't be produced?
I don't know why.
Can we look, please, at FUJ 0015 5830? You can see that the form appears to have changed a little bit in terms of the way it's printed, but it contains the same sort of information.
Yeah.
And if we can just scroll down, please. And again. Yes, you can see that this is a form version 4 dated November 2007, right at the foot of the page.
Yes.
If we scroll back up, please. The year is not completed. You see that it was completed by you on the 2nd of July.
Yes.
This is for the Cowley Moor branch, with some date ranges between July 05 and January 06. You'll see the standard format hasn't changed. Can you see that?
Yes.
And then if we scroll down, you'll see that the previous standard wording has been removed, and it seems to have been replaced by analysis of Horizon Help Desk call logs. Can you see that in the second box down?
I can, yes.
Do you know why that was?
I don't know why it's changed. I don't recall the form actually changing either, but yes.
Who was responsible for the design of these forms, i.e. the information that Post Office as a prosecutor was seeking from Fujitsu as a third-party provider of material?
I assume that the casework team back in 2000 or even before that drafted these forms and policies ready for when Horizon came in.
You would agree that the standard wording on the ARQ form that we saw before this one supports an understanding that any large computer system could suffer system malfunctions, and therefore checks needed to be made to exclude at least those that have been reported?
Yes.
Here, the position is changed. It's just asked for an analysis of the call logs. Again, do you know why that change was made?
I don't know.
Rather than asking for a positive statement, confirmation that there are no reported system malfunctions, that Horizon was working properly, to an analysis of the call logs.
I don't know the reason why it's changed.
In any event, you didn't ask for that in this case. You've marked it up as no.
Correct.
Why wouldn't you want to know in a particular case whether a sub-postmaster had made calls to the Horizon help desk about Horizon?
It's what the investigator is requesting.
Why might an investigator not want to know that his suspect or her suspect has made calls to the Horizon help desk?
I don't know.
What did you understand the purpose of all of this was, seeking this data, as the person responsible for seeking it?
So the purpose was for the investigation manager to advance the investigation. That's what this was designed for in the beginning.
But can you maybe look at it a bit deeper than that? What was the purpose of seeking this data from Fujitsu?
To back up what was happening in branch, to assist the case.
Again, did you have any deeper understanding than that? Or were you just sort of filling out forms?
Well, at this stage, filling out forms, we were just the interface between the investigator and Fujitsu. So the email came in, would complete this form or the other version, and off it goes to Fujitsu. I mean, if I go back to when I was an investigation manager, the only time I can recall obtaining logs was to demonstrate that certain transactions had gone through the system when they shouldn't have, things like that. I don't actually remember any audit shortages where I would have obtained logs.
If we go back to poll 3051793, and look at that box a bit further down, please. Please, could you obtain a standard statement which confirms the Horizon system for the above post office was functioning properly? Can you see that?
I can, yes.
Did you not think that in each and every case it was a necessary element of a prosecution to prove that?
Back then, no.
And why not?
Because if Horizon hadn't been mentioned, or there were no concerns by either party about Horizon, in my mind, I think it would have been superfluous to the nitty-gritty of the case.
And so you didn't consider it a necessary element of the investigation, everything else being equal, to prove that the system that produced the data that you relied on was functioning properly.
That was the assumption, in much the same way that prior to Horizon, you had Echo in Crown offices, Capture or Jackson's, I think, in Sub Post Office. I don't think we got any, as a matter of course, relevant logs from those systems.
And was there any policy or guidance on this? You're a criminal investigator. You're seeking to prove a loss by computer-produced evidence. You either do or don't need to produce some evidence of system reliability. And the reason that you do need to produce evidence of system reliability is as follows, and the reason you don't need to prove system reliability is as follows.
I don't recall a policy outlining that.
And again, we can see, although the forms are differently worded, in one case, some such data was to be sought, and in another it was not.
Yeah.
What accounted for the difference of approach? Why might it be needed in some cases and not others?
It partly depends on the case. I noticed one of the things there is barcode and car licence details. So primarily that would be nothing required, but if the case did relate to...
So I'm thinking more about the system integrity box.
The system integrity, I don't know, it's whatever the investigator indicated.
Yes, that can come down, thank you. In paragraph 58 of your statement, you say that the Post Office was required to pay Fujitsu for ARQ data over a certain amount of annual requests.
Yes.
And I think you say that the figure was around 720 requests in 2006.
Yes.
Can we look, please, at Fujitsu 402033? And can we look at page 16, please? So I've done that far too quickly. I should show you the front page first. This is a Fujitsu document dated the 28th of August 2006, headed Security Management Service Description. Can we just please look at page 16? And if we scroll down, please, to 2.4. It says this table, table 2, defines the limits on new and old data requests. And if we look in the box on the far right, the limit per year shall be the first of the following to be reached. 720 ARQ, or ARQs. Yes?
Yes.
Or 15,000 query days. Do you know what the query days related to? Do you remember? There is, in fact, a definition in here, but do you remember?
I don't remember.
And can we look, please, at Fujitsu 0008-0107? This, and if we just scroll down, please, for the date. 2008, bottom right, December 2008. Scroll up to the top, please. Same title, Security Management Service, Service Description, and go to page 17, please. Similarly, in the box on the right-hand side, 720 ARQs, or 15,000 query days.
Yes.
What happened, thank you, that can come down. What happened when that limit was reached?
I think if that limit was reached, we would then have to have paid extra. So we paid for these services as part of the contract. if we went over those, I think we got charged extra.
What was the amount that you were charged? Can you remember?
I can't remember.
Was it seen as a sum of a level that it was acted as a disincentive to seek ARQ data beyond the limits?
I don't remember, but yes, possibly.
We've heard evidence in the inquiry, it was on the 19th of October this year, from Alison Bolsover, who was a debt recovery manager. Do you remember her?
I do, yes.
And she said that it would have been worthwhile for the Post Office to obtain ARQ data before commencing action against sub-postmasters, i.e. before suspension or termination, and certainly before the initiation of any criminal proceedings. But the quotes that were being given by Fujitsu for doing that were astronomical. Do you remember that?
Yes.
Was cost essentially the reason that this data was not sought as a matter of course before suspension and termination?
Cost was one of the factors.
What were the other factors?
The other factors were whether we reached the limit of requests which would adversely impact on investigations. So, for example, in previous years, I think it was something like 350 a year or 30-something requests a month. And I can remember investigators sending in requests and say it was, I don't know, 20th of October, we'd already reached the maximum. So we used to ask the investigator, can you wait 10 days and submit it on the 1st of November? That way we could not exceed our monthly requests. That was alleviated more when it increased to 720, but yes, costs were a part of that as well.
At the time, did it feel like cost for the provision of ARQ data was a significant issue for the Post Office?
I would say yes, on the basis that costs and money spent throughout the Post Office was not frowned upon, but they wanted to, keep tight rein on every penny spent.
The judge that heard the group litigation in 2019 found that audit data should have been sought in every case where a sub-postmaster was possibly going to be suspended or having their contract terminated, and that the Post Office acted unreasonably in failing to seek such data before those events occurred, and that the commercial arrangements between the Post Office and Fujitsu did not justify the failure to seek the audit data, which was the best evidence of what had occurred and whether any bugs, errors or defects were operative. Was that something that you were aware of? Obviously not the judge's view, but the essence of what he was to find when you were carrying out this work?
No.
Putting it another way, was there an awareness by you and within your team that postmasters were being suspended and their contracts terminated without the full suite of data being obtained first, and that was potentially unfair?
I wasn't aware of that because I don't know what investigators would have requested Horizon data and when. I believe it wasn't every single case, so what you've said makes sense.
You must have been aware of what Horizon data investigators sought and didn't seek, because you were the gateway through which it had to pass.
the casework team were, but we never sort of said, right, there's been 100 cases this year, or we've had 100 ARQ requests, so that marries up. You know, we didn't reconcile cases against data requests like that.
Was there a view ever expressed within your team, or a view that you heard, that the Post Office regarded Fujitsu as an organisation which saw the Post Office as a cash cow?
I don't recall that. But personally, I thought Fujitsu were doing quite well out of the relationship.
And specifically in relation to ARQ data?
Partly in relation to ARQ data. I mean, I always found it a bit strange that if it came to the crunch, we had to pay a lot of money for, in effect, our own data. But that's contracts for you. But also, I seem to remember, I think Fujitsu, I might be wrong, got a penny for every transaction across the Post Office network, which is worth a lot of money.
Can we turn, please, to FUJ 0015 2212? You can see that this is a document, if we scroll to the foot, please, dated 2009. And if we go to the top, please, management of the litigation support service. Were you aware of something within Fujitsu called the litigation support service?
No, I didn't. I didn't view it as a group of people, but just as what they will provide us from a litigation perspective.
If you had to name people that provided litigation support to the Post Office within Fujitsu, who would you have named?
Penny Thomas,
yes.
Pete Sewell, Gareth Jenkins and Andy Dunks.
Anyone else?
Not that I can recall, no.
Can we go to paragraph 7.1, please, in this document? I'm sorry, my note omits the page number. Perfect, thank you. Under the heading Additional Litigation Support, Fujitsu's policy states, where additional information to that described in the standard litigation support service is requested, RMGA shall view each request on a case-by-case basis and in accordance with the change control procedure. Were you aware that the other than the standard provision of ARQ data, which we can see was regulated by those two documents that we just looked at, the 720 or 15,000 query days,
Yep.
There were litigation support services outside of that?
I don't recall. I don't recall.
And that this document says that Fujitsu were going to review each request on a case-by-case basis. Would you understand that to refer to the provision by Fujitsu of witness statements and the attendance of witnesses at court?
Yes, on reading that.
And it refers to the change control procedure. Do you know what a change control procedure is, or the change control procedure was?
No.
You didn't know about a formalised mechanism by which a document was drawn up that contained a specification for the service required, provided limitations on the service to be provided, and gave a cost or cost assumptions for the provision of the service. So it seemed like an amendment to a contract, essentially,
Right.
for a bespoke activity.
Yeah. I don't remember that, but...
Did you ever receive any of those or asked to comment on any of those? A change control notice?
I don't recall. I mean, I noticed at the top of this document, Jane Owen from security is mentioned.
Yes.
I'm not in there. The previous one you showed, I think Sue Lowther was the post office person. And the one before that was dated August 2006, which was before I was...
You were doing something else then?
Yeah, so I may have seen these documents or equivalents, but I don't recall them.
I'm thinking more about the outcome of them, namely if something outside the standard was required. Certainly Fujitsu thought that a rather specialised or rarefied change control notice procedure needed to be undertaken.
I don't recall.
We haven't seen any evidence of that. What we've seen is some emails being exchanged between people asking for things.
Yeah.
Can we look at paragraph 7.2, expert witness evidence? Fujitsu's policy says expert in-depth analysis and detailed, in inverted commas, expert witness statements, as opposed to witness statements of fact, are rarely required. However, in the event of such a request, RMGA will endeavour to provide, quote, expert witnesses who are able to give more detailed and specific evidence to support Post Office Limited's litigation activity. This expert, in inverted commas, activity shall be provided on a case-by-case basis and shall be dealt with in accordance with the change control procedure. Again, RMGA shall use reasonable endeavours to meet dates notified by Post Office Limited for the production of this material and support. First off, I think you can see that this policy draws an explicit distinction or difference between the provision of evidence of fact and expert evidence.
Yes.
Was that a distinction with which you were familiar at the relevant time?
Not that I recall, no.
Were you aware that Fujitsu drew a distinction between the provision of evidence of fact and expert evidence?
Not that I recall, no.
And were you aware that, I think I know the answer, that Fujitsu said that this specialised change control procedure needed to be brought into effect if expert evidence was required?
I don't remember that.
Was that distinction between expert evidence and evidence of fact ever something that you saw in practice in administering these ARQ requests or other litigation support requests?
Not that I recall. If a statement was required, Fujitsu would provide that statement. I didn't see any distinction between what's written down here.
So when we saw that ARQ request you filled out earlier, the MISRA one, asking for a witness statement which said that the system was working properly at all material times, I'm summarising, would you have seen that as a witness statement of fact or expert evidence or an expert witness statement?
Well, hopefully both.
And why both?
Because we would want the statement to say it was working correctly, if it was working correctly, and whoever provided the statement would be the expert providing that view.
Did you expect any such statement from Fujitsu to contain an analysis to support a suggestion that Horizon was functioning correctly or with integrity?
Yes.
Did you expect any such statement to explain what inquiries had been undertaken in order to be able to make a statement that Horizon was functioning correctly or with integrity?
Yes.
what analysis would you expect as an investigator to have been undertaken, if any, in response to a request that Horizon, for a statement which said that Horizon was functioning correctly or with integrity?
If that was in the statement of a person from Fujitsu, I would expect them to explain, not that I would understand it, what they've actually done to verify that the system's working correctly.
And putting it another way, was the request for ARQ data seen by you and your colleagues to be a request for Fujitsu to perform essentially an administrative task, i.e. harvesting data from the system and providing it to you? Or was it also a request for their qualitative analysis of what that data showed?
I would say both, given their knowledge and experience. Yeah, both.
At the time that you were either an investigation manager or you were working in the casework team, or when you were working as an accredited financial investigator, so in any of those roles, did you have the technical skill and knowledge to be able to subject audit data, ARQ data, to detailed technical analysis?
No.
Did any investigator have such expertise?
Some were more IT literate or au fait with technical things than others.
That's a slightly different issue. Did any of them have sufficient skills or training to be able to analyse the raw ARQ data?
I don't know. I don't think so. I mean, I don't think we relied on colleagues for that purpose.
Were you aware of any colleagues doing that function themselves, i.e. getting the data and trying to read it, trying to analyse it, and themselves come to a view as to what it showed?
I think the only person I can recollect who would get involved to that depth would probably be the crime risk analyst, which was Helen Rose at the time.
And at what time was that?
That would have been, well, between 2008 2010 and probably earlier.
Did she in fact carry out analysis of raw ARQ data?
I don't know if it was raw ARQ data, but I've obviously seen a document where she's looked at something and come up with a report or a view.
Had you as an investigator been trained to analyse ARQ data?
No.
Had you and your colleagues received any training to spot any errors, bugs or defects disclosed in the ARQ data?
Errors, bugs, defects, no. Not. I mean, I can't answer for them, but I don't think so.
Would you have been able to identify within the ARQ data whether sufficient information had been provided to you, i.e. the data set that you received, to be able to judge whether or not a transaction had been completed by the clerk or an SPM, a sub-postmaster, as opposed to being a system-generated transaction?
In the cases I can recall that I dealt with myself, I'd received adequate information from the transaction logs I'd requested.
What does that mean?
Well, if I can give you an example of a case, the sub-postmaster's got stolen pension books and he cashes 5 of them. Well, I used to get transaction logs and all 5 would have been cashed within the space of a minute. Whereas ordinarily, if they were genuine, you'd have customers queuing up and being paid out. And you would see that the time of the encashments might be 7 o'clock in the morning, which was 2 hours before the post office even opened. So that's the extent to which I would get transaction event logs to prove that stolen foils have been cashed before the office is even open.
I think in one of your earlier answers, you said that you didn't know or understand the distinction between what I've called standard ARQ data and enhanced ARQ data, the latter of which had the facility to show that a transaction had been system generated rather than SPM generated.
I wouldn't know.
And so I think it followed that you didn't have the facility to be able to look at the ARQ data you received and say, that's type A, not type B data.
Correct. I'd see the data. I wouldn't know which of those streams it came from.
Can I turn to address an issue concerning problems identified with ARQ data between 2007 and 2009, which led to the proposal to make changes to the standard, as it was called, statement. You deal with this in paragraph 69 to 73 of your witness statement. That document can come down from the screen. And so we're dealing here with a problem that has been spotted by Fujitsu with the ARQ data that's being produced and what was done about it. Okay?
Yep.
Can we start, please, with FUJ 0015 5399? And can we scroll down to Wendy Warham's email? So this is the 7th of January 2009. You're not on copy at this time. Directly to Sue Lowther and David X. Gray. Subject security incident. Sue, I've left you a voicemail as I need to update you on a recent issue that's occurred and been resolved, but does have some short-term impacts. In summary, the issue is as follows. In December 2007, and just note the time there, December 2007,
Yep.
and this email is being sent in January 2009. In December 2007, an occurrence was reported in one office where a stock unit rollover coincided with the end-of-day process running. This led to a previously unseen database lock where an administrative balancing transaction failed to be written to the local message store database. This generated a generic and non-specific software error which went unnoticed in the monitoring of events. A financial imbalance was evident and was subject to investigation by Fujitsu Service Support Centre and Post Office Limited. The financial imbalance has been resolved. A software condition was applied across the estate in early November 2008 to ensure that any such event generated would be monitored. Testing and correction has established that the unmonitored error does not occur elsewhere in the system. Impact. We need to work with Post Office Limited to check the ARQs and reconfirm the data integrity during the period of May 2007 to November 2008. Penny will do this. We need to discuss how we disclose the issue on the witness statements, and we have some words which may be appropriate. Both need to discuss and agree the words. Identify which witness statement we've supplied and are still awaiting court to confirm whether or not the data provided was May 07 to November 08, to A, ensure events have been checked, and B, to recall and replace witness statements, Post Office and Penny. Further action, automate the message store alerts on the system so that no manual interventions required. Education to ensure this type of incident is raised as a major incident in the security stack so we can communicate and manage in accordance with this type of in accordance with incident timescales. Apologies, this hasn't been communicated earlier, but the review of security incidents should improve this issue. So if we just scroll back up, please. This is talking about an historic problem with Horizon.
Yeah.
That may have had an impact from May 2007 onwards.
Yes.
which was discovered in 2007, December 2007, yes? An occurrence was reported,
Yes.
in respect of which a change was made in 2008, yes? But witness statements had been prepared for the purposes of criminal investigations and criminal proceedings, which did not disclose this database lock, which affected balancing.
Yes,
Correct? Is that a fair summary of this?
I think so.
This was quite a serious issue, wasn't it?
Yes.
Can we turn, please, to FUJ 0015 5400? And can we turn to page 3, please? If we just scroll, thank you. It's your email of the 7th of January to Rob Wilson. Can you see that?
I can, yes.
It's in relation to the same security incident. And you say, Rob, in relation to the standard witness statement Fujitsu provide, one, the following addition has been inserted. See bullet point 11 on page 5. This addition seems okay. It's just another check that Fujitsu conduct to ensure the security incident doesn't occur again. And the addition is window events generated by the counters within the branch timeframe in question are checked to ensure counters were functioning correctly. And then 2, the following additional paragraphs have been inserted, page 7. If we just read that, the insertion. In December 2007, an occurrence was reported in one stock unit, in one office, where a stock unit rollover coincided with the end of day, etc., etc. And you'll see that's drawn from the earlier email that we looked at. Can you see that?
Yes.
And so that was proposed to be inserted in the standard Fujitsu witness statement, i.e. revealing to people that there was a system fault which affected balancing transactions and which had not been spotted at the time. And you say, I personally do not see the need for these if there are no problems identified with the data relating to the case in question. Why inform anyone about a problem we've had within the network, but possibly at one branch, if it bears no relation or relevance? Why did you form that view?
Because at the time, if it didn't impact on post offices once Fujitsu had done their investigations, what was the point of putting it into a witness statement?
Do you not agree that the exchange that we looked at alerted you to the fact that there could be bugs in the Horizon system which impacted on financial integrity, including the integrity of audit data, and they weren't picked up by the system?
Again, I can't put myself back there, but I've mentioned previously that all computer systems have issues. I thought, I presume at the time, I thought this was a localised issue that had been flagged up. So I looked at the details as far as I could understand them, and my view is communicated to Rob Wilson, the head of criminal law.
But surely, Mr. Posnett, you realise that this wasn't concerning because it affected or potentially affected a small number of branches. The concern was it was an unseen problem that meant that part of a balancing transaction had not been recorded in the local message store, and Fujitsu's systems had not picked it up.
I can only repeat what I've just said.
Do you agree on reflection that that's a serious issue? That not only there's a problem, all computer systems have problems, but the Fujitsu systems to identify it at the time did not identify it at the time?
In hindsight, given what we know now, I would change that paragraph.
But even without what we know now, reflecting on it, is it not a considerable concern that what's described as previously unseen database lock had operated without the safety nets identifying it?
I can only say that what I've written there represented my personal view at the time, and that's what I communicated to Rob Wilson for his stance on it.
And putting it another way, it revealed that there could be unseen bugs in Horizon.
Yes, but I didn't look at that. I saw that as one localised problem.
But why?
Well, perhaps at the time, that's the only particular problem that's been referred to me. I didn't look at that and think, oh, there's bugs all over the place.
I'm not suggesting that it meant there are bugs all over the place. What it meant was that Horizon was a system that could have bugs that affected financial integrity and balancing, and the system did not reveal itself to have them.
I understand that, but again, I can't put myself back there, but to me, it reads as though it was a one-off issue that had been flagged up to me. And I've given my view, and then Rob Wilson's given his view.
Thank you. We'll end it there, sir. I think we'll have to pick that up tomorrow.
All right. So we begin again at 10 o'clock tomorrow. I'm sorry that your evidence has been truncated in this way, Mr. Posnett, but I'm sorry it's unavoidable this afternoon. I don't suppose you'll want to, but if you do want to talk about your evidence this evening, resist the temptation, all right?
Yes, sir.
Thank you very much, sir. 10 o'clock tomorrow.
Yeah.